child support,
Yes.
assessments, limited agreements, binding agreements, child supporters funds. I understand it is another area where people assume perhaps that a private promise settles everything, but you got to think, well, what are the actual options when it comes to child support? Um, Tell me a little bit about the different kinds of child support arrangements, Alan, and just give me a bit of an overview.
So there's pretty much just briefly two ways to settle child support if one party is to pay child support to the other party. The first is the Child Support Agency or Services Australia assess after receiving an application by one party, assess the other party as to their income, and upon their income being disclosed, they then come to a calculation or an assessment as to how much that party should pay the other party with respect to child support. Now that's usually determined by their income. It's also determined by how many nights per fortnight that parent who's being assessed spends with the child. So if they spend no nights per fortnight, then they'll be paying the highest bracket in accordance with their income for child support. But if they spend, say, 5 nights a fortnight with the children, then they potentially pay the lowest bracket within their income because they spend so many nights on a fortnight basis with the children. The other way, which doesn't involve child support agency assessments, is a binding child support agreement. And that's where both parties enter into an agreement, a bit like the binding financial agreement, but just solely child support related, and how much um, one party is to pay another party on a fortnightly basis or monthly basis for child support, and they agree to contract out of the assessment of the child support agency determination. So they're pretty much the which two sort of avenues you can take with respect to settling any sort of child support arrangements.
And the key difference, I imagine, will be very similar to the binding financial agreements, where if you want a binding child support agreement, you have to have both parties to it would have to have independent legal advice and the
Yes,
required legal certificates to ensure that it's binding. Um,
yes,
so it's very interesting the way that the child support is assessed, and the options there open to the parties. Either a limited child support agreement without advice, it's not binding necessarily, and then you've got the binding option where which might be negotiated as commonly part of settlements and
correct.
mediations in the family court jurisdiction, either prior to, during legal proceedings
Yes,
at some point when there's
as,
children
as
involved.
you know, Michael, sorry to interject, but as you
No.
know, with negotiating property settlements, one of the factors in negotiating property settlements is future need of a party. And if one party is seeking child support from the other party and they've entered into a binding child support agreement, and that says that they're paying, above and beyond what they would pay if they were assessed by the child support agency, then that sort of nullifies any future need argument with respect to the rest of the residual or the residual property pool. Okay, so that's why it is important that if you do enter into a binding child support agreement, it's not only done correctly, but can it then be used in further negotiations with property settlement?
And I'll summarise. Services Australia applies a statutory child support framework, like an administrative assessment. The amount may change when income, care arrangements, or other relevant circumstances change. Then there's the limited child support agreement, requires an existing child support assessment. The payments under the agreement must generally be at least assessed at the annual rate. Independent legal advice isn't mandatory, and it can include non-cash items like school fees or health insurance. And then you've got the binding financial agreement, which you touched on, which is it must be written, must be signed, both parties with independent advice from their lawyers and required legal certificates, may provide for an amount above or below the ordinary assessed amount, and changes in care arrangements may affect how the agreement operates or whether it continues at all. And and from my perspective as a commercial lawyer is, if I think about the drafting points, if I was involved in drafting a binding financial agreement, I think a properly drafted child support agreement must cover things like periodic payments, school fees, uniforms, devices, camps, medical, dental, therapy costs, extracurricular activities, health insurance, payment dates, reimbursement procedures, evidence of expenditure, annual increases or indexation, what happens if care arrangements change, what happens if a parent loses employment or sells business, and how disagreements are also be resolved. So I think my perspective, and based on listening to you and my understanding of that jurisdiction, and in particular how we draft contracts as well and settlement agreements, I would imagine with children and knowing family dynamics quite well, having a family myself, that those are the things that really need to be covered. You know, saying we'll just split the child expenses equally sounds simple, but until the first $20,000 school invoice arrives. So um, I suppose a binding financial agreement in that regard would at least offer the certainty, and and when it becomes commercially unrealistic to simply just rely on handshake agreements or common understanding, where the parties have probably already, if they're in that situation, have likely had a breakdown in relationship already, and so the communication is already going to be strained, and then you're asking them to sort of informally enforce child payment arrangements, and one party's always, I find often going to be left annoyed or upset or unhappy with the arrangement, or accusing the other person of not chipping in, or using their money, and not being fair on them. So this is where these sorts of agreements can become very useful. Don't you agree?
Yes, I agree. But particularly the job loss or business sale drafting within the binding child support agreement, that's very important because you might have a party who is in a well-paying job, earning a six-figure salary in the year, and the following year, after entering into the binding child support agreement, he's lost his job. Well, what happens then? He's still got this binding child support agreement, which he still needs to pay because he's entered into. Unless there was a clause in there that says, in the event of a job loss, this is what happens, it still binds this person to those obligations. So that's why it is very important that in the event of a job loss, that's encompassed in the binding child support agreement.
Yeah. All right. Now I just want to talk just very briefly about the family violence. We not want to. It's not something that we like to go too deeply into because it can be very emotional for people watching who have gone through it. But we have to touch on it, because it is often part of this jurisdiction, and to be honest, it touches pretty much every jurisdiction. Even I've lost count of the amount of commercial cases, general litigation cases, other matters have involved family violence allegations, which have affected the running of the case, personal safety intervention orders as well. So this, violence protection orders they do affect a lot of different types of legal work, and definitely this jurisdiction is one that's heavily affected by those matters in the family context. So safety changes the process. You know, when it affects negotiation, handovers, money, or compliance, it's something that lawyers have to work through, and it can be very difficult, especially when there's real genuine concerns. Sometimes there's real genuine concerns about the actual safety of the individuals involved,
Mm.
and we're not just talking about safety in terms of just verbal threats and so forth. We're talking about some scary sort of violence, and we're talking potentially anything from verbal abuse to financial, economic, all the way to potentially murder. And sadly, the reality is it happens, and it happens more often than people would think. So it's not something that I like to skate over and ignore. I think it's something that needs to be addressed and discussed because it seems to touch legal work, not just in the family jurisdiction, but broadly as well.
Well, that's correct. it does now with respect to the legislative changes which happened in June last year, where now they look at family violence allegations, which are going to be before the court, and it could ultimately determine an adjustment in the favour of the family violence victim if it is proven that the other party did perpetrate family violence against that person and the effect it took during the relationship. So it is very, very important now. There was a lot of talk about this prior to June last year during cases and the family court, but now it's actually legislated where there could be an uplift to another party. um, I think it's more than important now because it's not only affecting children for parenting aspects, but it's affecting even property division.
How does the court assess the risk, um, and what sort of reports or experts does it look at? You got things like family law reports, independent children's lawyers, risk assessments, and the court assessing the risk with family violence, especially when it's thinking about what are the appropriate parenting orders and the responsibility between the parties, and there's that question of unacceptable risk to the children, um, and the sort of the criteria the court has to work through under the Family Law Act. How does the court
Mm.
deal? How does all that fit in, Alan, when it comes to parenting matters? Those things.
Yeah. Look, it's complicated and it's probably not, we're not going to encompass it all in this podcast, but essentially, there can be a number of factors. For instance, if you have a one parent where there's been allegations made by another parent that that person has committed family violence, if they've ultimately been charged with a family violence offence and they're either pled guilty or they've been found guilty in a criminal court, that can be used against that person in determining by the family court whether family violence has been committed. Now, we all know that if there is a finding of guilt in the criminal court, it's more likely than not, it's almost certain that the family court are going to say family violence was committed against this person. Okay? If, for instance, in a criminal court, the person is not, it's not proven that they did commit family violence and they were successful in defending the charges, it does not mean that the family court still can't look at the same allegations before them and come to a different view because it's on a different standard of proof. As you're aware, Michael, it's, on the balance of probabilities, not beyond all reasonable doubt. So they'll look at these sorts of things. But if there's merely an intervention order, no criminal charges. Then experts get involved, such as your family therapists, child impact report writers, family report writers, who assess each individual of the family and the children and the family as a unit and each parent and how they interact with each of the children, and then come to a view as to the way they see the family unit. And if there are allegations of family violence made against one party, they more often than not are asked with respect to those allegations and what their responses are so they can make an ultimate determination which can assist the court when it comes time to them to ultimately decide how to resolve the matter and what they should do when making final parenting orders.
Is that how the court assess risk with the guidance sometimes from experts, external persons like that?
Yes. So they'll assess risk that way. Um, they'll also consider other courts and the findings that they've made with risk. So, for instance, as we all know, with intervention order matters, in family violence matters, if it's a police application, police always do a risk assessment on the respondent or the other party. If it's subpoenaed by the court, by one party in the family court, or by the court, which is a 69 ZW report, that they subpoena those records to see the risk posed by the respondent, they can subpoena that, have a look, or order it, have a look, and then that can weigh as to the risk against that party. So they can consider those assessments as well.